Alrighty, so this is We the People News one more time, okay? This may or may not be a two-part video, just depends how much I speak into this behalf. Alright, we never look straight forward, we always look around us, be able to protect ourselves by any means necessary. Check this guy out, he is awesome, okay? The Justice Revolution, okay? I've done a couple of videos in the past about it, alright? Um, let's go ahead and try to proceed forward on this. Uh, before we get started, this got a little bit of everything in there in this document that he's showing that he done on behalf of another. Okay, it's got challenge the jurisdiction of the courts. It's got uh, basically bill of attainers, which is administrative law. It's also got attorneys uh, trying to void things. And then it's also challenging the judge. All right, acting in dishonor. So it's got all kinds of little things in this particular document that he has done. Okay, so this is what I like about it because it covers a lot of bases in there, y'all. Let's proceed forward.
That guys, we I've got a lot to cover in our show today. Okay. A lot has happened over this past week. So you guys remember last week I was talking about the report I was writing up. You guys remember that about that lawsuit from my buddy Mike Brown?
Yes. Right.
So I got my report done. I want to share that with you guys. I'm going to share my screen. And I want to go through this because I feel like it's really important to go through. So let me see here. There we go. Okay, so this is the report, or the objection, I should say, to the magistrate's report and recommendation. Just a quick review. You guys remember, or maybe you don't, but if you do, when you file a federal district court case, chances are you're going to be assigned a magistrate judge. It's really high. Now, they will send you some paperwork asking you to allow the magistrate to handle your entire case from start to forward. Do not sign that paperwork. I cannot stress that more. These magistrate judges, for lack of a better term, are the minor league judges. They're the judges who are trying to get into the system, but they absolutely are not. The information I'm seeing from them is so far off in left field. It'll just make your mind. It'll make your head spin. So anyway, so what we did is I took the report that she issued. So what happens is, you file your lawsuit, the other side files a motion to dismiss or some other frivolous document. They refer that over to the magistrate judge. The magistrate judge goes through it. They go through your complaint, and then they issue their report and recommendation as to what the court should do with your complaint. For the long story short, this magistrate judge, here's her name right here, Cecilia M. Romero, and I don't care. She's a public judge. Her name can be out there. Cecilia M. Romero. She issued a report recommending that they grant the defendant's motion to dismiss. So I came back and threw it back in her face, quite literally. So the first thing I did was I'm challenging the jurisdiction of Cecilia Romero. I'm doing that through a voir dire. Voir dire. That is a Latin term. Really what you're doing is you're challenging the validity of this individual. It's typically, this process here is what is done to challenge the validity of a juror. So when you're selecting jurors, you're like, hey, I've got a voir dire of this judge, and I'm not even sure I'm pronouncing that right, but I think I am. Of this juror, I don't believe that they're valid to sit as a juror. You can use the same approach for anybody that is on your case. So
now I'm gonna pause it here for a second. Okay. Now I did check into YouTube on this, right? I cannot find anybody on YouTube of attorneys. Okay, YouTube attorneys, right? Not a single one of them has ever talked about using that against the judges or magistrates. So this is the power we the people have when we go in there without an attorney. And there we go again, right? Since we are not bar members, when he goes through these documents, the language he uses is more blunt, more direct, and calls them out on than any attorney would do this because they got to operate within the bar member club, right? Because the judge is a bar member, attorneys are bar members, so they got to operate in the same club. But because they're not in this club, then they use language that's more suitable for people. So, just saying, the voir dire, like DER, right? That runs up and down the street, is how it's pronounced. It's not spelt that way, but it's how it's pronounced. It's a Latin word, right? I'm sure the Latin way was correctly spelt. We're just misspelling things. But anyway, and this is what I like about this document because it shows a lot of different varieties that attorneys are not using that we, in fact, can use. Okay? And this is one of them. This is a very important deal. Okay?
I put the court on notice that this is a jurisdictional challenge. This court has noticed that Romero is required to take an oath to uphold the Constitution of the United States and maintain a copy of that oath at her place of service for inspection. Absent this proof, Romero is neither a de facto nor de jure officer of this court, requiring that this court disregard all of the papers filed by Romero while she was impersonating a federal officer. Okay? So that's the first thing I did. Thoughts on that first part so far, you guys?
So on that part, just so you guys know, there is a federal magistrate. Okay, magistrate is more of a clerk, and they go to recommend for the real judges, should they proceed forward, the real judges proceed forward on the case. Okay, and that's all magistrates. That's your local magistrate as well, right? They're really just clerks recommending for the higher courts whether they should proceed forward or not.
Jaw dropping. I can't wait to see where it goes from here.
Yeah, well, just wait.
I know.
So
Okay.
this is submitted already.
Yes, this was filed with the court. So Mike submitted this to the court earlier, I want to say earlier this week or late last week, one of the two.
Okay, and I got your pronunciation. It's voir dire, like deer.
Voyeur dire. Okay.
Voir dire, like deer in the headlights.
Okay, voyeur dire. Got it. Voyeur dire. All right, so one of the things that I really wanted to harp on, because I this is now the fourth case that this magistrate judge, has been involved with Romero. And so I harp on the fact that even if she is a bona fide officer of this court, she cannot show this court that she's complicit with her presumed duty to do equal justice under law by showing this court that she has ever recommended that a pro se litigant's case should go forward. Because in every single case that I've submitted to the court, every single time she's come back recommending that the motion to be dismissed be granted. Every single.
Just for short, attorneys use a voir dire mostly to kind of release maybe a jury member, saying it's not going to fit their agenda. Okay, that's really what it basically means. Okay, we don't like this person to be one of the juries, so they're going to use a voir dire, and just say, you may go home. So what he's doing is using that against the magistrate. Say, hey, she's not being in on her. She does not need to be involved in this case whatsoever.
Time. Every single time. So now the second thing here is I really harp on the grounds for objection, because when you guys see what's happened with this case, why I'm saying our ground is fraud on the court. Okay? Fraud on the court is defined as a fraud perpetrated by officers of the court so that the judicial machinery cannot perform in the usual manner its impartial task of adjudging cases that are presented for adjudication. All right? you'll see why I'm talking about this. This first one hits on it right here. So, and I apologize, for those of you who are watching, you guys can read this, but there are a lot of people that listen to us. So that's why I'm reading this for those who are listening. So my second contention is that her report is erroneous from the beginning to end. And here's where it starts. The defendant's motion to dismiss under Rule 12b-6, which is the one motion to dismiss for failure to state a claim, must be converted to a summary judgment motion, that's Rule 56, for summary judgment. And here's why. I said that this magistrate judge has misapprehended and misapplied the court's taking of judicial notice of exhibits filed with the defendant's motion to dismiss, without properly converting the motion into a motion for summary judgment. Now, while facts subject to judicial notice may be considered in a Rule 12b-6 without converting the motion to dismiss into a motion for summary judgment, Romero misapplies this standard here. And this is why. After review of the court record, this court will see that Brown, who is the moving party, the plaintiff, initially submitted his amended complaint on January 18th, 2022. It was received by the clerk of the court showing as document lodged, electronic court filing 35. This was the first amended complaint submitted by Brown in response to an earlier motion to dismiss and was made in accordance and with pursuant to the rules 15A1B. All right, I'm not going to go into the details of that. You guys can look them up. That's the Federal Rules of Civil Procedure. However, Romero didn't properly docket the amended complaint until August 2nd, 2022, 7 months after it was properly received by the court. Additionally, Brown has reason to believe that the only reason that Romero finally docketed this properly submitted amended complaint was in response to his request for a decision paper filed on July the 11th, 2022. Romero states in her report that the court granted the defendant's request to take judicial notice under the Federal Rules of Evidence 201 of the state court case docket and other case-related materials.
Okay, we're going to pause there again. Okay, and the reason why lawsuits are lasting so long is because of stupid things like this. Why was it 7 months, people? Okay, it's all uncalled for. And this is the reason why these stretch out for years. This should not take this long.
Doing this greatly prejudiced Brown's due process rights and prohibits him from his right to be heard in this court. The materials attached to the defendant's motion to dismiss occurred long after the filing of Brown's amended complaint, 6 months to be exact. Taking judicial notice of these facts constitutes an impossibility, unless, of course, Romero has a time machine and or can magically see into the future. So there you go.
The time.
And this is one of the points I was wanting to tell you guys, right? Lawyers wouldn't say that, all right? But since he is not bound to the bar chain, he can speak his mind on paper. And that's what he just did. He's calling out the nonsense. That it cannot be misconstrued. Gotta love that part.
Yes, that's good.
Yeah. I really wanted to hit this one hard.
That's a funny one.
So,
James,
yes.
can I pause you just for a minute for
Go ahead.
those that are new to all of this? Can you just explain very briefly what's the summary judgment is and why it's important?
So a summary judgment is basically stating that there is no material issue at odds. So there's no material fact at issue between between the parties, and that one party is entitled to judgment as a matter of law. So basically what it means is that if we were to take this to trial, a jury would find that the plaintiff is entitled to judgment after all of the facts are presented before the jury.
No controversy.
Exactly. There's no controversy before the court. And so this rule allows a party to ask the court to grant them their judgment based on that same principles. Like, hey, there's no controversy before the court. But what I'm stating is that there is a controversy before the court. and the court is greatly prejudicing our rights in favor of the defendants if they adopt this report. So, I won't go into more details of what I say here, but essentially this is what it comes down to. I said if the magistrate judge Romero wants this court to take judicial notice of these documents, the plaintiff's due process rights and equal justice under the law require that the defendant's motion to dismiss be converted into a motion for summary judgment after all parties have had time to submit supporting documents, affidavits, answers to interrogatories, or depositions in support of that motion. I mean, doesn't that just seem logical? You too? What's that?
You mean due process?
What did I say?
Is that, I mean, would that be considered due process? Like
Yes.
being able to go through all of those steps?
Yeah, that's exactly right.
Yes.
Due process requires you to have an opportunity to a notice and an opportunity to be heard.
Right.
So if this court adopts this report, they're violating this man's due process rights because they're not allowing him to be heard.
Right.
They're basically saying that even though he followed the court rules and properly filed his amended complaint 6 months before all this crap happened, the court would be saying, that doesn't matter. Yeah, it does. It absolutely does.
Mm-hmm.
So, I won't go over everything else here. I'll just touch on a few things here.
All right, so this has been long enough due to my interruption. Like I said, if you guys want to really go through here and listen on his without my interruptions, the Justice Revolution, check him out, okay? There's going to be two parts to this video, apparently. But, again, people, this is what we can do that the bars will not do. So, come to the next one. Bye, y'all.